18, and 19. Those have been emailed to you, so if you would take a look at those today, we will be looking for approval of those minutes tomorrow in our committee meeting. With that, then, we will open the hearing on, we're going to go right to House Bill 2125, allowing a copy of a will to be filed and admitted to probate, and allowing a will or a copy of a will filed within 6 months after the death of the testator to be admitted to probate at any time. So with that, then, we will ask Revisor Mr. Thompson for the bill brief.
Thank you, Madam Chair, and good morning, committee. This is Jason Thompson with the Office of Revisor of Statutes. House Bill 2125, as amended by House Committee, allows a copy of a will to be filed and admitted to probate, and allows a will or copy of a will filed within 6 months after the death of the testator to be admitted to probate at any time. The bill amends KSA 59-618A. Subsection A of that statute is amended to provide that a copy of a decedent's will may be filed with the district court in the county where the decedent last resided, along with an affidavit that complies with the section. The House Committee on Judiciary added subsection B2 that provides an affidavit filed pursuant to this section on or after July 1 of this year shall state whether the original will or a copy of such will is being filed with the court. And that's in addition to the other requirements already required for an affidavit. Subsection C is amended to provide that a will or copy of the will that has been filed within 6 months after the death of the testator may be admitted to probate at any time after such filing, subject to any other applicable legal defenses to such admission of the will. And I will stand for questions.
Thank you. Committee, questions for the revisor? Seeing none, then we will invite our proponent conferee, Joseph Molina with the Kansas Bar Association. Please introduce yourself and welcome back to committee.
Madam Chair, Joe Molina with the Kansas Bar Association. I appreciate you guys taking the time to meet with us again. We've talked to you on a number of different topics, and now will probably be the most mundane one so far. We're talking about wills and probate law. As some background, I am not a probate attorney, so we may all be learning a little bit as we go. House Bill 2125 does a very simple thing. It modifies statute to allow the filing of a copy of a will, and not just what we call the wet ink will. As we proceed and technology gets better, determining what is a copy and what is a wet ink signature becomes more difficult in the electronic age. What's happening is people are going ahead and they're filing things online, PDFs, and you can't really tell what is a copy and what is a wet ink. And that is important because different ways to contest a will are brought up if you use a copy. For instance, if you have a copy of the will, the person who presents the will must rebut a presumption that that will was not previously revoked by either intentional destruction or through marriage with the birth of a child or through divorce. Those things don't really, you can't contest those things on the normal way you contest a will, when you contest it for undue influence or you contest it for failure to follow complicity when creating the will in the first place. So by filing a copy of the will, people can challenge the will in another fashion. And under current statute, we don't know, right, we don't have any way for them to know that. And so we wanted to go ahead and change that probate code to make sure that you could go ahead and have notice that what has been filed in probate is a copy. And therefore, that's why we wanted to have the additional language in the affidavit, making sure that the affidavit notifies everyone that it is a copy, and that you may have to proceed a little bit more cautiously when reviewing the will when you open a probate proceeding. And that's the gist of the bill.
Thank you. Committee, questions for the proponent? I have one. So this will change long-standing law in Kansas that you have to file the original of the will?
It will be in addition, right? You can file the original if you have it, or you can, what we call is preserve the will. And this is the first step, right? If you want to go ahead and preserve the will, you have 6 months after the death of the individual. You can preserve the will. If you want to open a probate, that's a separate proceeding. So you've preserved the will with a copy or with the original, and then you would go ahead and open the proceeding of a probate. And then when you open the proceeding, then you would actually determine what the will says, who's the executor, provide notice to creditors, and then begin that clock running.
I'm sorry, I misspoke. So what the law would do, right now, you can only file the original of a will. You cannot have the filing of a copy of a will to have that will then
Preserved, yeah.
be preserved and the subject of a probate matter, right?
Under statute right now, you cannot do that.
Right now, okay. And I had questions that I think I don't have any longer regarding subsection C, that it still has to be that the will or the copy of the will must still be filed within 6 months after the death of the testator. This bill doesn't change that 6 months, correct?
Joe, I'm with the Kansas Bar, so you're correct.
And what section C then does is that, well, what does it do? You don't have to open your probate case within 6 months after the death. You can open up the probate case at any time. Is that what the change in subsection C does?
Joe Molina with the Kansas Bar Association again. Subsection C would actually help speed up the probate process. So you file the copy of the will, and then you open probate. Under old law, you'd have to wait 6 months before you could actually proceed forward with that preserved will. Under the language we have, you could open it immediately, and then that would speed it up a little bit. This would also provide quicker notice to creditors. We have a hard bar when it comes to creditors and wills. After 4 months of published notice, creditors are no longer allowed to make any claims. After 1 month of actual notice to a known creditor or one that is reasonably ascertained, if they do not file a claim against the estate, they are also barred. So by pushing this up, we speed up the process because probates on very complicated estates can last years, determining who is the rightful owner of what, selling property, converting certain things to cash to split among heirs. And so this will actually push up the date and make probate quicker on the front end.
And this may be a question for the reviser, and some of these probably have been reviser questions, so I apologize, Mr. Molina, but you've done a fine job. Thank you. Wasn't the purpose of the 6-month period to have all potential claimed original wills a period to be filed, so that's not just the first in line to file what they claim to be the will, that's then the will, that this would allow everyone is on notice, you have 6 months, all versions of what people claim to be the will, then have an opportunity to be presented rather than just the first one, and then it precludes all others. Yes, I guess, do you know that the...
Joe Molina with the Kansas Bar Association. KSA 592239 is the creditor estate statute. If you would pull that up, it sets out the timeline on when creditors must make a claim against a will. And certain creditors, if they're unknown, you got to open a probate, and then you have to do a publication in the local paper or in some fashion that will put them on notice. And then they have 4 months from that initial publication to make a claim against the state. After that 4 months, it is a hard bar. Sorry, you missed the deadline, you get nothing. When we're talking about actual creditors, say a mortgage, the executor needs to go ahead and open a probate, be appointed as executor, and then send a notice to known or reasonably ascertainable creditors. And once they send that notice, those creditors only have 1 month to make a claim. And if they do not, then they are also barred. And that is in statute 592239.
5929.
592239.
And I think my question was misunderstood. I don't mean the claims of creditors against the estate. I mean other heirs or beneficiaries under the will who might be saying, well, hey, that will that was filed isn't the real will. Here's the real will. And then you filed this will, 2 days after date of death and you immediately open the probate, you've then foreclosed that 6-month window for others who may say, especially since we're going to then file copies and not originals, for others who may be coming forward and say, wait a minute, I have the original, here it is. So I'm just concerned that maybe we might be precluding that opportunity. 6 months isn't a, it's not a 2-year window or something that we often have in statute. So I'm wondering what the policy thinking was by the Bar Association on kind of foreclosing that 6-month window.
Joe Molina with the Kansas Bar Association. That really wasn't our intent. Our intent was just to make sure that the new way of preserving wills, it was statutorily allowable. And if you wanted to chat about that, we can. I don't think it really does preclude heirs of the estate. I don't think it cuts them off. I don't think the language you have cuts them off. But I'm happy to chat with you about that at a later time and make sure when I get together with my experts.
Yeah, I would just be concerned that we're closing that window pretty quickly, especially with the filing of a copy and the will contest and things like that. But yes, Senator Thompson.
Yeah, really, it's kind of a follow-up to your question, Madam Chair. I just went through this with my brother down in Florida, and they have an accelerated probate process where if the estate falls under a certain threshold, they can speed up the probate process. Do we have anything like that in Kansas, and how would that affect it? In other words, you speed up the probate process, you go ahead and get everything cleared up to start spreading assets around, and then suddenly find out, oops, made a mistake. You have to try to claw back some of those assets to distribute it differently. I don't know if there's a cash threshold in Kansas and an accelerated probate process or not.
Joe Molina with the Kansas Bar Association. I believe there is, but any estate that has more money in it than cost, debts, and fees must remain open until those things are settled. I know that there is a tax threshold that we want to look at, but I'm not specific on the amount. But normally those move rather quickly through the system anyway. So I don't know if we have a specific probate thing that's an accelerated, but I do know that if you have more money in your estate than you owe, we're going to have to take a little bit of time and make sure the right people get what they deserve under the statute.
So it could complicate the process a little bit? I guess, yeah.
I don't, Joe Molina at Kansas Bar Association, I don't think it complicates it. I just think it clarifies the fact that people are now filing copies, and we want to make sure that there is a process on how we would go ahead and deal with copies of wills when you preserve them. Because right now, people can do it and we wouldn't know because the tech is too good. You can't really tell what's a PDF and what's a wet ink anymore because it's really, really good. And so this would specifically, the first part of this specifically would go ahead and make sure that we had statutory authority to file things in court that are copies when we deal with the will subject.
Thank you. Thank you, Madam Chair.
Thank you. Committee, other questions for the conferee? Seeing none, we will ask, are there any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, then any neutral or opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, then we will close the hearing on House Bill 2125. We will then open the hearing on House Bill 2153, increasing the criminal penalty for mistreatment of a dependent adult or elder person when the victim is a resident of an adult care home. And we will ask our reviser, Mr. Thompson, for a bill brief.
Thank you again, Madam Chair. Jason Thompson with the Revisor's Office. As you mentioned, House Bill 2153 increases the criminal penalties for mistreatment of a dependent adult or elder person who is a resident of an adult care home. The bill amends KSA 21-5417 to provide that mistreatment of a dependent adult or an elder person that results in physical injury, unreasonable confinement, or unreasonable punishment would be a severity level 2 person felony when the victim is a dependent adult who is a resident of an adult care home during the commission of the offense. mistreatment of a dependent adult or an elder person that results in a taking of property or financial resources would be a severity level 5 person felony when the victim is a dependent adult who is a resident of adult care home during the commission of the offense. And I will stand for questions.
Thank you, Mr. Thompson. Committee, questions for the revisor? Seeing none, we will invite our first proponent, conferee, Mr. Steve Carrere from the Kansas Attorney General's Office. Please introduce yourself and welcome back to committee.
Thank you, Madam Chair, and fellow members. First of all, I apologize. No one should have to see me twice in the same week. I know Willie would agree with that. But I appreciate you giving me time to testify today. Maybe I just misheard the revisor, but just to be clear, this would make severity level 2 felony with physical abuse. It would make neglect from an 8 to a 5. I think he indicated it was financial abuse. I don't believe we do anything related to the financial abuse unless I'm mistaken. So just to be clear about that. So you have my written testimony. The bill is rather simple. I just want to speak to you about the why to increase it for this particular group. And it really comes down to vulnerability, the difference in vulnerability when someone is in a facility. I am, as indicated earlier in the week, I'm the deputy in charge of the Fraud and Abuse Litigation Division. We handle a lot of elder abuse investigation and prosecution on the criminal side. We also have our Medicaid Fraud Division, which does mostly those individuals who are in a facility. They prosecute the crimes against those individuals. And not only that, but I also have, fortunately or unfortunately, I have a mother who's 84 years old who suffers from dementia. My father's 87. They do just fine. They live on their own in independent living. But that is primarily because my father does an immense amount of lifting and caring for her. And one of the things that I have experienced through that process is the loss of independence, the loss of choice, and the loss of liberty that my mother experiences. And I would tell you that that is on a spectrum, but it is on the far end of the spectrum when you end up in a facility. That would also be the same for dependent adults, say individuals suffering from developmental disability. It's that loss of choice or independence that causes them to be more vulnerable. And once you get into a facility, think about all the things that you no longer have the ability to make your own decisions. It might be that it starts with you may not be able to drive on your own, so then someone has to take you. It might be menu choices, right? That's one of the things with my mother. A menu is a diabolical thing for someone with dementia. So she now only gets 2 choices. Those are rather simple losses of liberty or independence. But now get further in that spectrum, you start to lose the ability to say when you go to the bathroom, when you change your clothing, when you get washed. That vulnerability is what we're talking about in terms of this bill and what it's designed to affect. Not that that can exist when you're not in a facility, but it certainly exists when you're in a facility. And what I want you to think about is, a couple years ago, I broke my arm and my leg. I ended up in the hospital. I'm not very good with ladders. Had it on both of the same side, right? If I had gotten out of the bed when I wasn't supposed to, and someone was upset about that, if they had tried to hit me or slap me, I will tell you, you don't have people coming to you and saying a 46-year-old with full cognitive capacity is being abused in a hospital. Why? Because the perpetrator understands that I might be able to respond both physically, but more importantly, I would tell someone, hey, that person just abused me. In a facility, that is not, and with elder and dependent adults who are suffering from, say, dementia or Alzheimer's, oftentimes they're not even able to understand they're a victim, let alone report it. And it's that vulnerability that is behind this bill. Frankly, that's just been increased by COVID, right? Because the number of people seeing the individuals, the number of people coming into a facility, that's decreased dramatically. Final thing, I'll leave you with this statistic. Elders that are 60 and over that are abused are 300% more likely to die within a 6-month period of time than those who are not abused. That's because the effect on them, both physically and mentally, is very different than, say, if I was hit in the face or if I was struck. And so I want you to think about that. That's the mindset behind this bill and why we're asking to increase the penalties. And I'll stand for questions if you have any.
Thank you. We're going to first ask, are there other proponent conferees in the committee meeting room or on WebEx? Seeing none, then committee, you also have in your committee folder proponent written testimony from Ernest Cutzley, AARP, Kansas. And with that, then we will open it up for questions for our conferee. This was the subject, I would say, of some debate on the Senate floor yesterday regarding adult care homes and the residents in them. And particularly, so I'm curious how this would act, especially when we're talking about COVID-19 and regulations and statutes and procedures regarding that. And in Section A1, unreasonable confinement, and Section A3, deprivation of treatment that are necessary to maintain mental health. Could you describe for the committee what would this look like for an adult care home who is following guidelines and statutes and is then having residents confined to their rooms for eating dinner instead of in the common area, and restricting visitors? And what does that look like for the adult care homes?
Sure. Number one, I don't think this puts any additional burden on the adult care home, but I can understand when I've testified on 2154-17, there's always a lot of questions about the definitions. The first thing I would tell you is there's always a prosecutor at the other end of this. So there's always prosecutorial discretion. So to the extent of, if there's a question of someone sitting at a table, that they're confined to their room to eat dinner versus downstairs in the dining hall. I can tell you I don't see those cases, but even to the extent that I did, I don't believe there's a prosecutor in the world that would try to prosecute just based on those simple facts.
Because we're talking about unreasonable.
Exactly.
That in the statute too.
Exactly, and that's the word that we're talking about. So what we're saying is someone duct taping someone to a chair because they might have Alzheimer's and wander, and the person wants to go take a smoke break, right? That's the type of unreasonable confinement. And again, to your point, it's the unreasonable piece. So, but I always just want to be clear, there is always a prosecutor standing there having to make these decisions and use their discretion about those definitions.
I would say myself and my family has particular interest in this because my father-in-law is at an adult care home. And so it's, I support that. We're looking at actually creating a subsection of the bill that would be particularly geared towards those residents in the adult care homes, and particularly when families not always able to go in and things like that. So appreciate the effort of your office in advocating for this and for those residents who, like you said, are some of our most vulnerable Kansans and family members. With that, do we have, and I'm actually glad to see this, that this might help resolve some of the questions that we were having on the Senate floor yesterday about these kinds of issues and concerns that were raised. Do we have any other questions for our conferee? Senator Haley.
I too join you, Madam Chair. Greatly appreciate this moving forward. What is the reporting system for? How is that conveyed, or how will this? Are there mechanisms, you know, from an evidentiary standpoint? Do we have? How is it? How is that? What are the mechanics of?
Great question, and I'll try to give you a 30-second answer for a somewhat complicated matter. So under 39-1401 and 39-1430 is the reporting mechanisms that exist in regards to reporting something to KDADs if the person is defined as a resident, or under 1430 if they are defined as an adult. Essentially, think of it this way: 1430 applies if you live in the community, 1401 applies if you live in a facility. And both of those agencies, DCF under 1430 and KDADS under 1401, have hotlines or a website where you can report abuse, neglect, or exploitation of an elder or dependent adult. Then under those statutes, if they believe a crime is being committed or has been committed, they're required to send that to my office and to the local law enforcement agency, and that's a report of a crime. Now, some instances get reported that way. Other times someone will just make a direct report to the law enforcement agency. So it can occur both avenues on the criminal side.
Thank you, Madam Chair.
Thank you. Committee, other questions? Seeing none, then we will ask, are there any neutral or opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, we will close the hearing on House Bill 2153. Committee, we will now turn to opening the hearing on House Bill 2121. And ask our reviser, Mr. Thompson, for a short bill brief.
Thank you, Madam Chair. Jason Thompson again with the Revisor's Office. House Bill 2121, as amended by House Committee, adds a definition related to defendants who abscond from supervision in the Criminal Procedure Code and then in the parole statutes. Section 1 amends KSA 22-2202 to provide that absconds from supervision means knowingly avoiding supervision or knowingly making the defendant's whereabouts unknown to the defendant's supervising court services officer or community correctional services officer. And then Section 2 amends KSA 75-5217 to provide that, as used in the parole statute, absconded from supervision means knowingly avoiding supervision or knowingly making the defendant's whereabouts unknown to the defendant's supervising parole officer, court services officer, or community correctional services officer. The House Committee on Corrections and Juvenile Justice changed the culpability term from the introduced version. It was intentionally to knowingly, as it appears in both sections of the bill in here. So again, as introduced, it was intentionally avoiding supervision, and as coming to you from the House, it is knowingly avoiding supervision. And I'll stand for questions.
Thank you, Mr. Thompson. The vote in the House was, I see, 101 to 22 noes. So committee questions for the reviser? Seeing none, we will invite our first proponent conferee, Scott Schultz from the Kansas Sentencing Commission. Please introduce yourself and welcome back to committee.
Good morning, Madam Chair, Committee. Scott Schultz, Executive Director of the Sentencing Commission. Thank you for having us here today to support this particular bill. This, as Jason indicated, would add a definition of absconding from supervision as it relates to those probation entities that we have here in Kansas, whether that be court services, community corrections, or KDOC parole. So the main thrust of this particular request is to essentially just simply add a definition of absconding. There is meaning in this particular word as it relates to being in the probation context, and that can mean for an offender the difference between receiving a jail sanction of 2 or 3 days or being revoked to prison for their original prison sanction. So that is, in my written testimony, I've kind of stepped through the State versus Dooley case, in which the Supreme Court made a finding that it was necessary for the state to to prove certain things and the court to make certain findings that the conduct actually requires a heightened level of intent to be able to determine whether the individual has absconded. And so again, the differences here is between failure to report and absconding. And if you fail to report, it is a violation, but at the same time, you may only receive a 2 to 3 day prison sanction. If the court determines that absconding has actually occurred, they can bypass that particular graduated sanction and revoke the individual to prison. So having this particular definition in place, we believe will give guidance to community corrections, court services, the judiciary, attorneys in determining, as well as parole, to give them guidance to make that determination between failure to report and absconding. And it will hopefully provide a little bit better continuity to those practitioners statewide as far as the application of the phrase. And so with that, I would stand for questions at the appropriate time.
Thank you. Next, we'll invite our next proponent conferee, Jennifer Casella, with the Council of State Governments. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. Jennifer Casella, Deputy Program Director with the Council of State Governments Justice Center. We have been working with the Kansas Criminal Justice Reform Commission over the last year to take a look at the criminal justice system and opportunities to improve success for people who are involved in the system and maintain public safety in the community. And one of the items that was noted is that there is no current statutory definition for when a person absconds from supervision. And in Kansas, there are the 3 different supervision entities: court services, community corrections, and the Kansas Department of Corrections. And so as Mr. Schultz said in his testimony, House Bill 2121 will provide that consistency across those 3 supervision entities to ensure that the same threshold is being met for when someone is defined as absconding from supervision. During our data analysis, we found that 58% of prison admissions in fiscal year 2019 were for supervision condition violations. Absconding from supervision is part of that 58% of prison admissions. And so the Kansas Criminal Justice Reform Commission, in their work, identified multiple targeted approaches to address this issue through different sanctions and incentives, access to programming, and also interagency re-engagement units to help those who are failing to report on supervision, struggling with supervision success, and at risk of revocation. And so this definition will also assist in that re-engagement unit and pilot process to take a look at how to successfully engage and kind of when that threshold is for re-engagement on community supervision. So I stand for questions at the appropriate time. Thank you, Madam Chair.
Thank you. Next, we will hear from our next proponent conferee, Patrick Armstrong with the Council of State Governments. Please introduce yourself and welcome to committee.
Hi, Madam Chair. This is Patrick Armstrong with the Council of State Governments. as the previous time when our organization testified, we have other staff on the line to stand for questions at that time, and I'm not providing any additional testimony at this moment, but we'll be here for questions if you all need us. Thank you.
Thank you. Committee, in your committee folders, you also have proponent written testimony from Shelley Williams, Riley County Community Corrections. And we will ask then, do we have any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none. Committee, we will open it up for questions for any of our conferees. Yes, Senator Gossage.
Thank you, Madam Chair. Just a technical question. I've noted that earlier on another day, a couple of times, we changed intentionally to knowingly, or somebody has. And could you tell me, from legal terms, what's the difference and why that matters? I'm just curious.
Thank you, Senator. That would be a question, probably a policy question for one of our conferees.
And probably, this is Scott Schultz with the Sentencing Commission. In Kansas, we have 3 levels of intent, from the highest level of intentionally to knowingly to recklessly. And so those different levels require different levels of proof. And so the original intent, no pun intended, was to look at this as a higher level, and specifically, and that's why you see in the bill itself, it originally was drafted as intentionally, and Jason mentioned this as well. The House corrections was split on that, just as actually the commission was when we actually passed this out to introduce it to you, in that what level of intent is required here for an individual to be that the state would be required to prove. And so that level is not recklessly, it is not intentionally, but the middle knowingly at this particular time. I hope that answers your question, Senator.
Thank you. I have a follow-up question. We saw in a different bill earlier this week the word willfully. Willfully in the context of House Bill 2093, and there was some question about willfully driving down the road one direction versus another. So if our conferees could explain why willfully wasn't used in House Bill 2121, and you said there were different levels of intent, if you will, intentionally, knowingly, and recklessly, but you didn't mention willfully. So where does willfully fall in the hierarchy of burden of proof for the state?
Madam Chair, Scott Schultz with the Sentencing Commission. I think that might be, and I don't want to speak out of turn, and Jason may actually probably be able to have a little bit more articulate rationale. Our previous statutes used to actually have willfully and knowingly, and that was actually has been over time has actually been taken out. But I probably would just defer to Jason, because he can probably articulate it much better than I can.
I was thinking the same thing, Mr. Schultz, that let's hear from our revisor regarding where willfully would fall into the hierarchy, if you will, of the burden of proof, and do we want to be consistent in how we use certain terms? Mr. Revisor, Mr. Thompson?
Thank you, Madam Chair. Jason Thompson again with the Revisor's Office, and thank you for putting that faith in me. We're lucky that this came up recently, so we were able to dig back into it. We've had some flashbacks to the Criminal Code Recodification Commission, where we made this change, and the many hours of debate about culpability terms. Mr. Schultz is correct. The current criminal code, which is where we're referencing culpability now in most cases, it just has the 3 levels: intentionally, knowingly, and recklessly. So we do our best as revisors to encourage you as the policymakers to use one of those 3 terms. And that's best practice, because those are the 3 used in our criminal code. However, in Chapter 8, the vehicle code, where that flee and elude statute is, there are a few examples, less than I thought, thankfully, where they still use willfully as a culpability term. I had mentioned to the committee that I thought that was generally associated with knowingly because of the way that was used in the prior code. It was pointed out to me by a couple of folks after that that there's some case law that indicates that might be more akin to intentionally under our current definitions. There are some specific intent sort of elements to willfully, and it might be a little different than the general intent of knowingly. And recklessly, of course, is a general intent crime too. So you have intentionally, which is specific intent, and then knowingly and recklessly are more general intent. And willfully tends to lean more toward intentional from the case law that I was pointed to. But it's not exactly clear. It doesn't really fit into either of those. So we're trying to avoid willfully, I guess, is the short answer. And we might be able to eradicate it from the flee and elude statute if the committee is willing to consider an amendment on that issue when the time comes. But for now, we have some case law and we have the criminal code, and we're trying to use either in this bill knowingly, as the House suggested, or intentionally, as the bill is introduced requested. Those were both proper culpability terms in our opinion.
Thank you. Committee, other questions for the conferees? Yes, Senator Haley.
I appreciate this, Madam Chair, this discussion, because again, on the Criminal Justice Reform Commission, as I was, this was some discussion at that time, and I hope we do get clarity for the various levels of culpability that are ascribed based on these different and seemingly shifting definitions. I guess my question is certainly to thank the conferees, not only from the Sentencing Commission, but also from CSG and also the written one, Shelley Williams, and to ask Mr. Thompson, when it comes to this, if there was much discussion about this, because I see the House Committee are the ones that changed the Criminal Justice Reforms Commission's very well reasoned and interim work to change the term. And was there, Mr. Thompson, such a discussion in changing it? If you recall, I don't even know if you staffed the House Committee during that time, but what led them to change very well-reasoned work of all the conferees that are here and the commission to change to this different malleable standard, if you will, from intentionally, as we suggested, now to knowingly?
Mr. Thompson.
Thank you, Madam Chair. This is Jason Thompson again with the Revisor's Office, and I hope that Mr. Schultz can chime in afterwards if that's okay with the chair. I think he'll have some more, policy-oriented response, but I can give you the response that yes, I was able to observe that day. There was I don't know, lengthy, maybe not the right word, but definitely a discussion of this change. Members of the Sentencing Commission, particularly Representative Heiberger, argued in favor of keeping it intentionally. Certain other members of the committee argued in favor of switching to knowingly. Most of what I heard reflected the debate that was had at the Sentencing Commission, which I'm hoping Mr. Schultz can articulate some of those arguments from both sides because they were heard there in the committee and in the Sentencing Commission before this was proposed. And it essentially is just a policy choice. The case law that was brought to the committee's attention, the Dooley case, leans more toward intentionally, and the policy that you can choose is to make it knowingly. The legislature can set a different level of culpability if they choose, and that is what the House committee chose to send your way. And you would have the policy choice here again, whether you choose knowingly, intentionally, or you could even choose recklessly if you like. But I think that level of intent's kind of been put off the table. So that's kind of how we got there, and hopefully the conferees can illuminate a little more.
Madam Chair, before Mr. Schultz, should he so chime, could I just do a brief follow-up on this point from Mr. Thompson? And thank you, Jason Thompson, for this. In the level of the standards, I'm having difficulty with this, full disclosure. You listed in this order, intentionally, knowingly, and recklessly. Is that the order of degree of culpability? I mean, in my mind, it would not be to that degree from intentionally, knowingly, and recklessly. But is that the various levels or the degrees of culpability based on the mens rea or the ability of the actor? In
Mr.
that
Thompson.
descending or ascending order?
Sorry. Go ahead, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. Correct. That is the order. The order that I gave them in is the order in KSA. It's 21-5202, 5202, culpable mental state. And the hierarchy listed there is number 1, intentionally, number 2, knowingly, number 3, recklessly. And the statute goes on to say, if you list a crime as intentionally, you have to prove that burden. And it's a higher burden. It has a specific definition. If you list a crime as knowingly, you can prove knowingly or intentionally. And either one is satisfactory because you've actually proved your burden or proved more than the required burden. And finally, if your statute says recklessly, you can prove recklessly, knowingly, or intentionally because you've exceeded, met, or exceeded the burden. So it's very clear from the statute that it is that hierarchy, and it's each of those has a specific definition.
Thank you. And finally, Madam Chair, is not recklessly mitigated from culpability? Say someone were impaired at the time, and can they not form, if there is recklessly not the inability sometimes mitigated to form the ability due to, usually it's impairment is what we're talking about. So is that the greatest standard if there's an intentional impairment that led to recklessness or recklessly performing an act?
Mr. Thompson.
Thank you, Madam Chair. I thought I knew where that was going at first, so I'll answer it the way I thought it was going. I'm not sure I'm going to get there. The recklessly standard does require a conscious disregard of a substantial and unjustifiable risk. So you can have a defense to recklessly that is sort of voluntary intoxication, for example. That's the one that comes to mind recently. That defense can be asserted to a recklessly or a knowingly sort of offense because you were unable to form that mental state potentially, but that's less likely to succeed in an intentional crime. So there is some difference in which offenses could be applied in a general intent sense, recklessly or knowingly, and which defenses might apply in an intent, a specific intent case. And I don't know if that gets to quite where you were going, but that's what I was thinking.
Mr. Thompson, thank you so much. Madam Chair, let me say that I've been dealing with this gentleman for over a decade, and every time he speaks, I yet learn something new. So I appreciate, as always, his insight. And thank you, Madam Chair, for your indulgence.
Thank you. I wholeheartedly agree with the comments that the reviser is very knowledgeable. Thank you for that. I have one follow-up question for our conferees. Did you determine there were 22 no votes in the House on this? Did you follow up with any of those members of the House as the bill was working its way over to the Senate to determine the why?
Madam Chair, Scott Schultz, Executive Director with the Sentencing Commission. I think that is reflective again of how the vote actually went in House corrections as well. I think it was the difference there between those that believed that intentionally was the correct level versus knowingly. And so I think that's why there wasn't a unanimous vote in that particular situation. And you had that's my only understanding of what the no votes would have entailed.
Thank you. Committee, other questions for the conferees? Seeing none then, are there any neutral or opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none then, we will close the hearing on House Bill 2121. Committee, we have about 36 minutes left of committee. The next bill on the agenda for hearing passed the House, comes out of the House 122-1, so we can see it's not controversial. So we have 3 proponent conferees. It's House Bill 2361. We will open the hearing, but we're going to limit the testimony time for each of our proponent conferees to 2 minutes each so that we can then get to work some bills that we've been performing diligently on. So with that, could we have a short bill brief on House Bill 2361 from the reviser?
Thank you, Madam Chair. Jason Thompson again. I'll do my best to keep this very short. You have a sort of long bill brief in front of you. This House Bill 2361 does authorize the Supreme Court to adopt rules establishing specialty courts. It also creates the Specialty Court Funding Advisory Committee and a Specialty Court Resources Fund. New Section 1 does require the Supreme Court to adopt rules for the establishment and operation of one or more specialty court programs within the state. The Chief Judge of the Judicial District can establish those programs in accordance with those rules. And then subsection B creates that Specialty Court Funding Advisory Committee that will be in charge of evaluating resources available for these specialty court programs. It will consist of the chairs of the Judiciary committees in both houses, the chair of the Legislative Budget Committee, members of the Legislature appointed by other leadership folks, and then some ex officio non-voting members that are listed there in the bill as well. The other provision that I'll point out from this this section is that if a person is sentenced to participate in a specialty court program and successfully completes that program, the person's sentence may be reduced or modified, but it can't be reduced or modified below the minimum sentence required by law. Section 2 then goes into the sentencing statutes 21-6604 and provides that ordering a defendant to participate in a specialty court program is an authorized sentencing option when a person has been found guilty of a crime, which is kind of a necessary change to make sure that is an option for a judge to sentence someone to this. And finally, Section 3 amends our expungement statute, 21-6614, to provide that if you participate in a specialty court program, there's a special expungement provision that applies to you. And with that, I'll stand for questions.
Thank you, Mr. Thompson. Committee questions for the reviser? Seeing none, then, we will invite our first proponent conferee, the Honorable Daniel D. Kreitz, Kansas District Judges Association. Welcome to committee. Please introduce yourself and in your best 2 minutes, tell us why this is a bill that we need to pass favorably out of committee.
Yes, I am Chief Judge Dan Kreitz, and of the 31st Judicial District. I'm also the president of the Kansas District Judges Association. I'm also, just for your information, a member of the PIC committee that writes jury instructions in Kansas, and I'm very familiar with the things you've been discussing. I'm here to talk to you about drug courts. We have a drug court in Allen County. My written testimony provides great detail. I tried to describe a therapy court to you. Many of the committee members are familiar with me because I've been in the building a lot and testified many times, but in years past. But the bottom line is this is a bill that's dear to my heart. I'm a big believer in therapy courts. We have one here that's about 10 years old. I describe our recidivism rate, which is phenomenal. I want to stress that I set it up, that a very valuable team, unbelievably dedicated professionals presented and execute this. I mean, we have drug court this afternoon at 1 o'clock, or I would be there in person. Bottom line is these courts are essential in my mind in Kansas. We've been operating a long time, very successful. One provision that I think is essential that you maintain is in section 1B7, where local districts can basically keep control of their local money that they have been applied for, been able to local maybe trusts, etc. In our situation, we have many local people that give to our drug court, and we've also are on our 4th federal grant. We've been audited twice federally. And we have total compliance, but nothing but praise about our drug court. And again, that I'm the leader. Yes, I'm the one that created it, but the work of the staff is amazing. But I'll finish with this real quickly. When you hear somebody that tells you that they've been using methamphetamine and other drugs daily for more than 30 years, and they graduate from drug court, in a graduation ceremony where they have to give a graduation speech, they've invited their family there, etc. And they tell the history of where they started and where they are now, They now have jobs. They're now tax-paying citizens. Their families are back together. It is heartbreaking. And there are not any of those graduation ceremonies. And we've had over 100 where I was not left in tears. They are emotionally. Drug courts are extremely challenging. For court staff, it's just all extra work. But they appreciate it, and dedicated staff make it happen. And with that, I would be available for questions later. I stand on my written testimony, which tries to get away from the policy and provide information. If you have not seen a therapy court, you need to go see one. Johnson County has an excellent veterans court. There's many great drug courts in Kansas, and they are worth your time to go see. They're life-changing.
Thank you, Judge. Thank you. Appreciate your testimony. Next, we have Thomas Stanton from the Kansas County and District Attorneys Association. Please introduce yourself and welcome to committee. Do we have Mr. Stanton on WebEx? No, we don't see him on WebEx. So we will move then to our next proponent conferee, Amy Raymond, with the Office of Judicial Administration. Please introduce yourself and welcome to committee.
Good morning. Thank you, Chairperson Warren and members of the committee, for the opportunity to speak with you today. I am Amy Raymond. I'm the Director of Trial Court Programs for the Office of Judicial Administration, and part of my responsibility in that role is oversight of the specialty courts across Kansas. The Chief Justice, in her State of the Judiciary report, identified specialty courts as a strategic goal in maximizing access to justice and promoting justice across Kansas. The Supreme Court already has a couple of rules related to specialty court standards and guidelines, and recently adopted a new rule creating a standing specialty court committee that would make recommendations regarding development and administration of specialty courts across our district courts. The Interbranch Funding Committee proposed in this bill would engage in work that's parallel to our work that's already underway. At this time, OJA believes that it has sufficient staff to work under this bill. Of course, if, based on the activity of the bill, if that position changes, we would let you all know. But I appreciate the opportunity to testify in support of this today, and we also appreciate your continued interest in developing specialty courts across Kansas. I'd be happy to stand for questions at the appropriate time.
Absolutely, thank you. Committee, you have in your committee folder proponent written testimony from the Honorable Glenn Braun, Judge of the 23rd Judicial District. And do we have any other proponent conferees in the committee meeting room or on WebEx? Seeing none, we will then open it up for committee questions for any of our conferees. Seeing none, then, we will thank the conferees for their testimony and their appearance today. I know someone who's, I think, one of the first attorneys working in the Veterans Court, and so it's been a very successful program, so glad to see the bill being proposed to expand that, and want to thank all of our conferees who appeared today and provided their time and testimony for the committee. And we will then close the hearing on House Bill 2361. Committee, I think one of the bills we heard today regarding absconding kind of ties in nicely to a bill we heard earlier this week, HB 2093, regarding fleeing and eluding, and kind of brings us up to the question we had in committee regarding willfully as written in the statute, and we had some discussion about that. So if you'll pull out your folder on House Bill 2093, we will work House Bill 2093, and we'll have a brief bill brief from the reviser.
Thank you, Madam Chair. Jason Thompson again. Pull that one back up real fast. All right, as you'll recall, House Bill 2093, as amended by House Committee, is the bill that changes the penalties for the crime of fleeing or attempting to elude a police officer. and adds a provision regarding evidence in a prosecution for theft of a motor vehicle. So there's two different pieces to it. One is amending the crime of fleeing or attempting to elude, including adding several new kinds of violations that enhance the penalties. And the second part was amending the statute regarding theft to provide that if you're fleeing and eluding in a stolen vehicle, it's prima facie evidence of intent to deprive and commit theft. I'll stand for questions.
Thank you, committee. Any questions for the revisor? Seeing none, committee discussion on the bill. Committee, I have an amendment to propose to pass out to discuss that kind of follows up on some of the discussion we had, and just to learn what the will of the committee is regarding page 2 of the bill, and where we are looking at actually throughout the bill, the use of willfully. You'll see the amendment changes willfully to knowingly. So we'll open it up for discussion on the amendment and see what the will of the committee is on that. Yes, Senator Haley.
That you are bringing the amendment, Madam Chair. Everyone on the committee and probably else knows that there was some extensive discussion, and I certainly appreciate the amendment coming forward. Oh yeah, sorry. I appreciate the amendment, and in light of all the discussion on that and the bill we heard today, I would be supportive of the amendment and appreciate the chair's bringing it. Thank you.
Other discussion on the proposed amendment? Yes, Senator Pyle.
Yeah, could you explain, Madam Chair, why you chose knowingly and not intentionally?
Sure, thank you, Senator Pyle. It was just a result of some of the discussion that we were having in committee, so just wanted to know the will of the committee, and this was an amendment to have a discussion on. And I think now that we've heard some testimony on House Bill 2121, it kind of aligns with the term knowingly found in other statutes in the statute book. Committee, do we have a motion regarding the amendment? Yes, Senator Gossage.
Yes, I move we pass the amendment for Bill 2093.
Is there a second? Senator Wilborn, committee discussion on the amendment. Seeing none, then you've heard the motion. All those in favor, aye. Aye. All those opposed, nay. The motion carries. We're back on the bill. Further discussion on the bill. Seeing none, do we have a motion? Senator Gossage.
I move we pass the bill as amended favorably out of committee.
Senator Wilborn.
I have a question, Madam Chairman. Would this be an opportunity to combine the contents of House Bill 2121 into 2093? If you give that some thought, I apologize.
Yeah, that's a good question for our revisor. Would we be able to move House Bill 2121, amend 2193 by putting House Bill 2121 into it, and we could discuss House Bill 2121. Mr. Revisor.
Thank you, Madam Chair. Jason Thompson again. I hesitate to say yes just because of the breadth of this bill. It is not a typical criminal bill, although there is this criminal provision and the other criminal provision. It's for some reason we hesitated and made it motor vehicles. I do have an alternative possibility for 2121, another criminal bill that you have heard and are considering working, and I believe that might be the bundle you're looking for, but if you wanted to do it here, we could try to make that work.
Go ahead, Senator Wilborn.
Thank you, Madam Chair. I withdraw that question. If the good revisor would tip us off as to a similar criminal bill that we could start combining the contents to make it easier to carry on the floor and to pass on through conference. So I'll withdraw my question. Thank you.
But I am interested in a tip from the revisor about what we could combine into this bill that we've heard previously. Mr. Thompson?
Madam Chair, are you asking about 2093?
Yes, are there other criminal statutes we could amend 2093 and add to it?
Madam Chair, sorry, Jason Thompson again. My hesitation is only because this is styled as an act concerning motor vehicles, and I wanted to make sure there wasn't some non-criminal provision that was in here. On my quick look, I'm not seeing it, so it might be constitutionally sound to say this is a crimes, punishment, and criminal procedure bill. I just don't want to make that mistake and put it in jeopardy. You do have 2121 is a criminal bill you have heard, and you also heard 2076, which is a criminal bill regarding sureties. And you also heard 2153 just now, which is a criminal bill regarding mistreatment of a dependent adult. So you've got 3 or 4, and you've got options as you're aware.
Would we be able to bundle any of those other bills that we heard today into this bill? Mr. Revisor?
Madam Chair, Jason Thompson again, and let me just look at 2093 a little more specifically before I say yes and get you into trouble. All of the provisions in section 1 appear to be criminal, even though they're in the motor vehicle code. And obviously section 2 is in the criminal code. So yes, if you wanted to turn this into a crimes bill rather than a motor vehicles bill, I think we can do that. And so your options are, again, as I presented, 2 of the bills you heard today, 2121 and 2153, and a bill you heard previously, 2076, about sureties. Those are the ones on my radar anyway.
Would we be able to amend it with all 3 of those? Mr. Thompson?
Madam Chair, subject to the committee's desire, yes, I don't believe you have a rule like the House does prohibiting multiple bills. And I think that even would be within the House rule of no more than 4, if I'm not mistaken. So if you wanted to add 3 more, I think you could.
Thank you. Senator Haley, did you have a comment?
Yes, ma'am. Thank you, Madam Chair. I appreciate the ability of the revisor to look at these. 2093 has been, there's a motion, if I understand correctly, that was made by Senator Gossage to move the bill out favorably as amended. I don't know if there was a second. If there is room for that second, I would like to make the second to Senator Gossage's motion. I feel that, trying to say as even-handedly as I can, that the issues that are contained in 2093 probably need to move forward without further impediment or with some of the potential maneuverings that adding additional measures might cause in conference or what have you. There might be, as represented by Mr. Thompson, other opportunities to bundle and to further discuss, potentially obfuscate the issues of the individual bills. But I would hope that I can second, you'll accept a second to Senator Gossage's motion on 2093 as amended with the new language that was just added regarding knowingly, replacing knowingly, and that we would act favorably on the amended bill.
You have a second to the motion. We have a comment or a question from Senator Wilborn.
Thank you, Madam Chair. I apologize to the committee for suggesting that we look ahead to the opportunity to combine some bills for expediency, but I do concur with the good ranking member that this is maybe not the right time to do it, but we can look forward in the future to taking advantage of what we can. Thank you.
Thank you. Committee, discussion on the motion. Seeing none, then you've heard, would you like to close on your motion?
Yes, so
You close.
I close.
Thank you. Committee, you've heard the motion. All those in favor, aye. All those opposed, nay. The motion carries. Committee, I think having looked at House Bill 2121 today, I think it'd be a good idea to ask the revisor, are there items we could bundle today with House Bill 2121 and possibly 2153? Mr. Revisor?
Thank you, Madam Chair. And just before I answer that one, could I make sure on the last motion, that was a motion to be passed as amended? I had Senator Gossage is making the motion and closing. Did you end up recording that as Senator Wilborn's second or Senator Haley's preferred second? I just wanted to make that clear.
I did Senator Wilborn make a second before Senator Haley did? Okay, we have conflicting reports, but so we'll take Senator Haley's second. And yes, the motion was to pass out favorably 2093 as amended.
Very good.
Yes, so do we have ability to bundle House Bill 2121 and 2153 today?
Thank you, Madam Chair. Jason Thompson again, and just as a reminder to the committee, if the question posed to our office is, can you put these together in a way that, is a single subject and is, able to move forward as a constitutionally sound enactment, that's really the question I'm being asked and the way that I choose to address it. So keep that in mind. Yes, 2121 and 2153 are both in the criminal code. We are generally allowed to combine those bills. And as a reminder, 2076 is lingering out there as a criminal procedure bill that you would consider as well, that could be into that bundle.
Thank you, Mr. Thompson. Committee, if you'll recall, House Bill 2076 clarifies that bond agents seeking discharge as a surety are required to return the person released on bond to the court in the county where the complaint subject to the bond was filed. We heard that Monday this week, and I would entertain a motion to work House Bill 2076, and if we could amend it to add in House Bill 2121 and House Bill 2153, if that would be appropriate according to Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. And just because I was trying to look at all three bills, I'm trying to find the one that would be the best base bill, probably the one that has the most content, so we can move the others onto it. 2076 happens to be one section. It's very short, so I would hesitate to use that one as the base. It would be easier to put that on a different bill. 2121 is looking like a good choice. If you're asking for an opinion on which one would be the easiest to move other bills into, I think you might stick with what you originally announced here, working 2121 and having an amendment to add 2076, which is short, and potentially an amendment to add 2153, which is also just one section.
Thank you, Mr. Thompson. Committee, you've heard the suggestion from the revisor, so we will take that up, and we will then work House Bill 2121, which we had heard today. And I would entertain a motion to amend 2121 by adding in the contents of House Bill 2076 and House Bill 2153. Yes, Senator Wilborn.
Thank you, Madam Chair. I'd like to make a motion that we move the contents of House Bill 2076 into the House Bill 2021.
Is there a second? Yes, Senator Bowers. Committee, you have heard the motion. Any discussion on the motion? Yes, Senator Haley.
Thank you, Madam Chair. I kind of, what I do is I know that these are going to conference. I have a concern, and it seems like some of the concerns that were expressed by members who were on the Criminal Justice Reform Commission may have involved, who actually ended up voting against the bill on the House side, 2121, may be again around the discussion we've been having on that word, intentionally versus knowingly, the whole degree of culpability. That's one point. So I would certainly hope that the underlying bill 2121, the committee, since we're going to conference evidently, might consider putting back the original language. I should say that I'm a little eased a bit on culpability of intentionally and knowingly being almost synonymous based on the representation of our revisor, Mr. Thompson, but there seems to be some, it's in the minority, but some pushback on 2121. You've been kind enough, Madam Chair, to point out what the vote count has been coming over from the House, and it is in the distinct minority, but it exists, and so I don't know if it has to do with that or what it has to do with, but we might consider restoring the bill to its original form, which I think would help if we're bundling other things into it, other matters into it.
Thank you, Senator. Is that, I guess are you making a conceptual amendment that in Section 1 of House Bill 2121 on lines 8 and 9, we restore intentionally for knowingly?
Yes, I would make that motion.
And is that a conceptual amendment that is acceptable to the revisor in the form that it's a conceptual amendment and not a written amendment?
Madam Chair, Jason Thompson with the revisor, and two comments, if I may. First, I follow the amendment, so if the committee follows it and the chair will allow it, fine by me. And second, you do have a pending motion to amend to add 2076, if I'm not mistaken. So you're still on that motion.
Thank you. Do we have a second on the motion to, I think we did get a second for the motion to amend House Bill 2121 by adding in the contents of 2076. And that was some discussion by Senator Haley on that amendment. Then there was an amendment. I don't know, is that a substitute amendment? Is that where we are, Mr. Revisor, or where are we on that?
Thank you, Madam Chair. Jason Thompson again. It could be used as a substitute amendment or a substitute motion, I should say, if Senator Haley so desires. It's not necessarily the same topic, so you could address this amendment and then that amendment. So that there are some options here, depending on what the maker of the motion wants to do and what the chair wants to allow.
Committee, we have a second on the motion to amend 2121 by adding in the contents of 2076, and we have a second on that. So let's have discussion on that first, and then we'll look at the content of 2121. So do we have discussion on the motion to add the contents of 2076 to 2121? Seeing none then, you've heard the motion. All those in favor, aye.
Aye.
All those opposed, nay. The motion carries. Then we will turn to the motion to amend House Bill 2121, the conceptual amendment by Senator Haley. Do we have a second? I'm not seeing any. Senator Corson seconds the motion. Committee discussion on the motion. Yes, Senator Haley.
Only to say, Madam Chair, now we're going to conference on this bill, and we've amended the bill, and if it passes out favorably, and I'm just trying to help mitigate all the ancillary discussions on what are now two different measures by, getting it back to it was, so we won't have too much at conference to discuss. The original bill as it came over, or as it was introduced, was intentionally, And looking at it now, 22 members in the House, some who are going to be key to the conference committee, voted against this bill. So I'm just trying to help move the process further by taking it back to where it was originally. And I would hope that we would send over the best product that we can to work with the other chamber. Thank you.
Senator Gossage.
Thank you, Madam Chair. It would appear to me that if we had 22 who voted against, and we were to change it back the way it was, the majority who voted for may be against. I just think that's something we should consider.
Thank you. Other discussion on the motion? Seeing none, then would you like to close on your motion? Committee, you have heard the motion. All those in favor, aye. All those opposed, no. The motion fails. We are back on the bill, House Bill 2121. Is there a motion to amend House Bill 2121 to add the contents of House Bill 2153 that we heard today, increasing the criminal penalty for mistreatment of a dependent adult or elder person when the victim is a resident of an adult care home? Senator Wilborn.
Thank you, Madam Chair. I would like to make that motion that we move the contents of House Bill 2153 into the House Bill 2121.
Senator Baumgartner with a second. Committee, you've heard the motion. Discussion on the motion. Senator Haley.
I just want to express my concern that we're bundling too many bills, some of which, I mean, this bill was unanimous, and I think we certainly want and need it. I don't know why we are, it was a clean bill. It won't go to conference. It wouldn't, it's a standalone bill. Why it wouldn't just be passed out, you know, on its own, and why it's going to be bundled into what is growing to be an increasingly burdensome discussion on the bundled bill. I just don't know if it makes the best possible path. I'd rather see it remain a standalone bill, frankly, and not be bundled in with something else that's potentially controversial.
Thank you. Senator Wilborn.
Thank you, Madam Chair. As the good ranking member knows, this is part of the process, and the people that overwhelmingly supported one bill will have to make a choice, those 22, whether they cannot support the other one. So part of the combining of these bills is to move the process forward, which should help expedite the process going into the closing days of the session. Thank you. I move my motion.
Committee, you've heard the motion. All those in favor, aye. Aye. All those opposed, no. The motion carries. We are back on the bill. Would you like your vote recorded, Senator Haley?
Please, that I voted opposed.
That was his no vote. Please have that recorded. Thank you. Senators, committee members, we are back on the bill, House Bill 2121. Do we have a motion? Senator Wilborn.
Thank you, Madam Chair. I would like to move House Bill 2121 as amended out favorably for passage. Thank you.
Thank you. Senator Gossage, second. Thank you. Committee discussion on the motion. Seeing none, then, you've heard the motion. All those in favor, aye. All those opposed, nay. The motion carries. Committee, then, we are approaching 12 o'clock noon and want to keep you on your schedule and out of time, on to your next duties on time. So thank you for your attention, everyone, today, and your hard work. And we will be meeting tomorrow, and I am confirming that we will be meeting Monday for the confirmation hearing of Rebecca Dickinson as an appointee for the member of the Crime Victims Compensation Board. So please make sure to be present. Senator Baumgartner.
Thank you, Madam Chair. What will we be working on tomorrow?
Tomorrow, yes. Please be prepared to work on possibly Senate Bill 301, possibly House Bill 2377, and possibly Senate Bill 150, and possibly Senate Concurrent Resolution 1608. That should keep us pretty busy, but if we have additional time, we may be picking up some of the other bills that we have previously heard. So please make sure you have your amendments ready, and we will have a busy day. Tomorrow, we will be hearing what I would consider one of our last couple of COVID-19 response pieces of legislation, House Bill 304, which is the contact tracing bill to extend its provisions, which are set to expire May 1st of 2021, to extend those with no sunset date. So please be prepared to discuss that. And we also have on the agenda, just a moment, I'm going to pull it up here. We also have a couple of court services bill regarding offenders to get driver's license and things, and a lot of these were not controversial in the House, so we will take up the most controversial ones first and see where we are, and work the bills we've previously heard as well. Any other questions? With that, then again, committee, thank you for your time and work and consideration today. We are adjourned.